Wednesday morning, April 1st. And it's not an April Fool's Day that we are going to learn about declaimants and disclaimers and all those fun things in taking up S-179, the Uniform Disclaimer of Property Interest Act. This morning, we all get to be educated on this. And I personally am excited to really dig into some technical kind of legal stuff instead of it's true. So, thank you for being here, Mark. If you could introduce yourself and proceed, I appreciate it.
Sure. I'm Mark Langen. I am the head of the Trust and Estates Department at the Dincy Law Firm in Burlington, Vermont. I also serve as the chair of the Probate and Trust Law section of the Vermont Bar Association, which I think I've served since 2015, in my 11th year of doing that. I've been before you with various uniform acts. I was the chair of the Uniform Trust Code, chair of the Uniform Power of Attorney Act. We had a Directed Trustee Act, a Decanting Act, and now I'm bringing you the Uniform Disclaimer of Property Interest Act. So it is exciting. Buckle your seatbelts.
We always appreciate having you here. So thank you.
Thank you. I'm going to start off with just the big picture, and the real reason is why you should pass this act. First of all, I just Googled yesterday. Baby boomers were born between 46 and 64. So 46 means they're turning 80. We are going to see the largest transfer of wealth go from one generation to the next in the next 20 years. And it's important that we get our laws correct, because there's going to be a lot of issues with the transfers that go from one generation to the next. So this is very important. We have a Uniform Disclaimers Act, but it's really old. And quite frankly, it's really terrible. It's got to go. It's got some real problems in it. And I think that this act, which is a sort of a second or third generation of the Uniform Disclaimer Act, is much, much better. And it deals with issues that have arisen since the first act. But let me tell you about the first act when it came about. Is that in 1976, the United States Congress passed the Tax Reform Act. And in it was a gift tax provision, because basically what the big thing that they were doing is they were combining the estate tax and the gift tax together. So it didn't matter whether you transferred property during your life or at death. It was all going to be under one tax scheme. And in it, in the gift tax section, they basically said, if you want to disclaim property, say, I don't want this gift that someone has given me. I don't want this inheritance that someone has given me. If you want to disclaim it and not have it be treated as a gift for gift tax purposes, you have to do four things. You have to disclaim within 9 months of the interest being created. It's got to be in writing. It's got to be delivered to the person who would be transferring it to you, like the executor or the trustee or a relative or whatever. And you cannot take an interest in the property before you disclaim it. So you can't say, oh, I'll take the interest in dividends and, oh, no, now I want to disclaim it. Once you touch it, it's yours, and then it would be a gift. Okay. So basically, that's where Congress was coming from. We're going to treat it as a gift unless you meet those four rules. And then the Uniform Commission turns around and passes a Uniform Disclaimer Act that says you can only disclaim if you do it within 9 months in writing, don't take an interest, transfer to the deliverer. And they crowded out in the common law, which has no time limit whatsoever, as to when you disclaim. And so if you miss the 9 months, you're stuck. You own it, and you have to transfer it. And we don't really need that rule anymore. And it went too far. And subsequently, when Uniform Acts came out, the Uniform Commission always puts in a section saying, oh, we aren't crowding out the common law. But this was too early. They hadn't gotten to that, and they did. And when I moved to Vermont, I said, what? You can only disclaim if you within 9 months? What if you don't care if it's a gift? You know, you should be able to disclaim. That's a gift tax issue. It's not a disclaimer of a property interest issue. And that's what this act will do. The first and most important thing this thing does is say you're not confined to 9 months. You can disclaim later. Your tax consequences with the federal government may be different, but that's that's your problem over there. But you can still disclaim even if you miss the 9 months. And let me tell you why that's important. Because it's when the interest was created. Okay, when the interest was created. So here's what's happening. You have mom and pop, and they have wills. And let's say dad dies first, and he has a trust for mom that's going to bypass her estate. But it says when mom dies, it goes to the kids. Okay? And the parents don't tell the kids anything. And 40 years goes by, and mom finally dies. And the kids say, oh, I'm inheriting this money from this trust. I want it to go to my kids. I want to disclaim it. I don't want it. I want to pass it down to my kids. Too late. Because the interest was created when dad died 40 years ago. And he didn't even know about it. The kid didn't even know about it. But Congress didn't want to get into a situation where people are just saying, oh, I didn't know about it, so I should be, the 9-month clock should start ticking when I know about it, So.
Karen.
Isn't that what a trust is for? I mean, you may not want to tell your kids then because
yeah,
I guess they'll have a field day and hoping you die quicker, but
well,
again, isn't that what a trust's for?
No, I trust does do that, but your wills do too. A lot of people don't tell people what's in their will.
So you're saying this is all stuff that if people aren't I'm looking for words, up to date with making sure they have a will and a trust?
Yeah, I am. Yeah.
Okay.
So it's a good thing that, and actually that law is even more pernicious in that this is what happened is that there are two types. So let's say there's a beneficiary and the husband leaves wife the thing, the whole estate. It's in a trust for her. And he gives her two power. He has the option to give her a power. One is a general power of appointment saying that it's under the code where it says if you can appoint it to your estate, your creditors, the creditors of your estate, it's going to be includable in your estate, wife, when you die. Okay. Or you could say just the opposite. You could say you can appoint it to anybody except for your creditors, your estate, and the creditors of your estate. And if you do that, in the first instance, it would be includable in mom's estate. In the second instance, it would bypass mom's estate. And guess what? What happens? The effective disclaimer is if it was a general power of appointment, then 9-month clock would start ticking when mom died. But if it's a special power of appointment, no. It started clicking when the dad died. What's the difference? It's the kid. You don't know whether you're going to get it, whether your mother's going to give it to you or not. She might say, no, I want to give it to my other kid. And you've been such a rotten kid. You're not going to inherit anything from me, But it's a different, it's just crazy because the kid doesn't really know if they're going to get it because there's a power of appointment out there, regardless of whether it's special or general, which is a tax concept. And the clock should start ticking for them when they know that they've got it. And that's what this act does. It says, hey, until you know you're going to get it, that clock's not going to start ticking for you. Okay. So that's a very important, that alone is the reason to pass this act.
Two questions. So how long has this current one been in effect?
It has been, so when the Tax Reform Act of 76 was passed, it's only 2 years later that the Uniform Commission came out with the first act.
Yep.
We passed it in 86, about 8 years
This has been in effect since
It's
86.
and we've been sort of working around it.
Okay. So I guess for me, that brings up the question, and I think you shared why now is because there's this age transition that's going to happen. But I also am like, well, if we've been working around it, why?
Why do it?
Yeah, why do it?
Uh-huh.
Because it seems like there's a workaround. And I'll just share my second question because maybe it comes together. What is the downside of transferring? Because it sounds like you said, like, if the parents got it, but they're like, oh, I want to give it to my kids, that they would have to transfer it rather than say, I'm going to disclaim it and have it just go to my kids. I'm like, why can't we just transfer it? What's the downside?
There is a couple downsides. What if it's real estate? Who pays the transfer taxes on it? You know, whereas if you say, oh, it doesn't touch me because I put my hand up and said it's disclaimer, it would just go right to the kids without any transfer tax. Federal gift taxes, it'll pass that. But also in our estate tax, gifts, if you make a gift, it's includable in your estate when you die for Vermont estate tax purposes, if you die within 2 years of the date of the gift. If you disclaim and it goes by, then there's no gift. You know, so that's another reason. But to your point, there are 2 states in the country that have not changed like us, you know, and there are 25 states that updated. So we will be the 26th state to pass this version of the thing. We need to update like the other 26 states.
But can I just add another thing? So my understanding is that this will go to Ways and Means, because it just sounds like there's tax implications for it, that there's potential revenue that.
There's gift taxes, but guess what? Vermont doesn't have a gift tax. We don't really have any tax consequences here. So
it's a federal gift tax.
it's a federal gift tax. Yeah. So that's all about gift taxes.
Oh,
So that's the main reason, my main sales pitch for why we need to get rid of this, is that we should be able, like under the common law, the other elements of a disclaimer, got to be in writing, you can't take an interest in it, you got to transfer it to somebody, you have to notify somebody, you can't just silently, say, I've disclaimed it, it's got to be, sort of known, and we'll get into that. So, but those are the issues. What also this act does, it does, as I said, it will clear up when that disclaimer is effective, when you have time to do it. And then there were two issues. Number one is when you have joint property, which I'll talk about, where more than one person co-owns and if there's a right of survivorship. There were some complications, and this act clears that up. And number two is that there are, besides disclaiming property, we sometimes want people to disclaim powers. Because as I said, sometimes when you have a general power of appointment, those assets are includable in your estate. And you might say, I don't want that power. I'm not going to accept that power. And so then it wouldn't be includable in your estate for estate purposes. So then there are also third party type of disclaimers like executors, trustees, people who have powers of appointment, that this has been expanded to talk about those issues. So that's a good thing. So I thought I would do a walkthrough, which I think was that. And I think this is the type of statute that lends itself to an easy walkthrough. So I have to say you had a late night last night with immigration and ICE and stuff. So this is probably a nice respite for that. Yeah. So starting at the beginning, I'm in 30 seconds. 4101, 4102, 4103, 4104. I'll take them all together. 4101, short title, what the title is. 4102, definitions. There's a few definitions. I don't think they're worth going into any of them. There's no questions about them. 4103, the scope. It applies disclaimers of interests and powers and properties. So we're going to talk about both of those, powers and properties. And then 4104, this supplemented by other law. That's why I said earlier, it crowded out, in the old days, it crowded out the common law. This is the standard provision that is in almost every single uniform act that says we're not crowding out, we're supplementing the common law. We are not crowding it out. Okay. We got 4 done already. Okay. We're up to 4105. This is the main event. Okay, this is the heart, the meat of the statute. So it says that a person can disclaim a power or an interest in property. Again, the dual concept of disclaiming powers or disclaiming property. B, parents can disclaim for children. That wasn't in the old act. That clears some things up. So if you have a minor child, the parent can disclaim for you, provided the parent and the child do not have a conflict of interest. So I kind of have that case right now. We want to terminate a trust, and basically it would go to the people who are getting the distributions now, but their children and that sort of thing, and they want to disclaim for their children. They're cutting off their children. They have kind of a conflict of interest. Like, we're going to take the money and you're not going to get anything. You know? So if that happens, they can't. But generally, we need parents to just be able to disclaim. C.
Can I ask you a question? What would be the situation? I'm trying to, when would they want to disclaim? I'm just trying to understand the situation where one would disclaim for their minor child. I'm not sure I understand.
When they would disclaim for the minor child?
Yeah, what would be the situation where
where they don't have any monetary, you want to change who the trustee is. You want to change a power in a trust. There's nothing dealing with the beneficial interests at all. It's administrative. And the parent says, yeah, this is good, and my kid would agree with this. You know, there's a lot of times when parents think it's their economic interests are harmonious with their children.
Okay.
Well, I would say most of those changes that are done under the Uniform Trust Code are of that nature. You know, you're usually particularly changing trustees, you know, when you want to get a trustee.
So not, you don't get any of the interest in this property.
Yeah.
Okay.
105C, it's got to be in writing. Okay. And now what's interesting is
That is D.
D. Oh, you do? Okay, sorry.
The same.
Yeah.
Parent was C, right?
Yeah.
Yeah, the parent wants C. Okay. So the next one is it's got to be in writing. And so a couple things there, Aaron. Number one is that under our law now, it can be by email. That's in writing. Okay. Two, it's got to be signed. Number one is you'll see it back in the other thing, electronic signatures are fine. So getting back to that email concept, that's going to be fine. And also it adds from the will section that if someone's giving a will and let's say they don't have the ability to sign, they can direct somebody else to sign for them. They've added this into this statute. This is new. It's not in the old Disclaimer Act. This is an improvement. And number three, it's got to be delivered. And that's section 4112. We'll go into delivery in a second. Next section. It can be your disclaimer doesn't have to be all or nothing. You could say, I'm going to disclaim a fraction of it. I'm half. I'm going to disclaim a percentage of it. I'm going to disclaim 75% of what I'm getting. I'm going to a monetary amount. I'm going to disclaim $100,000 of what I'm getting, and the rest can go to my kids. It could be for a term of years. I'm going to disclaim for X amount of years, and also you can disclaim. You can limit a power. I've given them this power, and I'm going to accept some of the power, but there's aspects of this power that I'm going to disclaim. So it talks about there's more flexibility. This is new. It's not in the old statute. It becomes, next section is, it becomes irrevocable when it's delivered or becomes effective, whichever last occurs. So that's sort of a complicated thing, but I would say that it just when you deliver it, but sometimes there could be a delay in when it becomes effective, and therefore whenever it does become effective, it will happen. And then the next section, a disclaimer is not a transfer, an assignment, or release. Getting to your point, what is the effective fee? You know, what if you do transfer? Yeah, who pays the transfer tax on that? And that comes up later in the act. Okay, so that's the main event. We have two ancillary provisions, 106. So the disclaimer takes effect at the time the instrument giving the property becomes irrevocable. So I gave you an example of husband and wife in the trust, and it became irrevocable upon the husband's death, and therefore the interest was created there. Okay, so and then, but I said if there was, well, let's say there was a power of attorney that mom, or a power of appointment that mom had, and so she could change whether the son is going to get it or not, then it's not irrevocable for the son. And therefore, he can disclaim when mom dies. Another thing that's happening is, and in our state, is the use of enhanced life estate deeds. Very, very popular. Okay. I'll digress here for 30 seconds to explain what's happening. In Medicaid planning, you have to spend down to $2,000 of your countable assets. Your house is not a countable asset. Okay. But if you put it into a trust, it is a countable asset. But what you can do, Medicaid can also pick up in Vermont, it can reimburse itself out of your estate. So what people are doing in Medicaid planning is they're saying, mom basically is saying, I'm giving it to my kids, but I'm retaining a life estate with the power to sell and to mortgage. That's where it becomes enhanced, because most of the life estates don't have that. And if you have those powers, then the Department of Health will consider that you own it, and therefore it's a non-countable asset for eligibility into Medicaid. Okay, very popular. When you do that deed, you don't have to really notify the kids that they're the remainder men, you know. So they might not know that they get the house until mom dies, you know. So there are these delays, and therefore that would start to, that's when when it becomes irrevocable. So that life estate deed really isn't irrevocable because mom has retained the power to sell and can change it at any time. So until mom dies, then it becomes irrevocable. That's when you can start to disclaim.
Okay, and Ken has a question.
Is that the part you have to do that 5 years in advance?
No.
Or they can take it? There's something 5 years in advance, right?
Yes, yeah, the general, everything. The house is sort of a special asset, so that's been termed non-countable, but anything that is a countable asset, then you've got a 5-year look back rule.
And did that just get changed from 3 and went to 5 years? Like if you go into a nursing home or something like that?
No, it's been 5 years for a long. It's actually 60 months. Yeah.
Okay. All right. Thank you.
So if you have a portfolio account, a checking account, those are all countable assets. You better get rid of them for 5 years before you apply for Medicaid. So
Thank you.
Wasn't the clawback? I thought they could claw back the house above a certain amount, something. Or financial threshold for that. And that's why they use the enhanced life, right? So you can't claw back.
no, I think that no matter what, even if the house is worth $2 million,
There's a substantial equity limit. Sorry to jump in.
oh, what there is? What, Matt?
There is an equity limit.
Oh, an equity limit. Yeah. It's not, that must be relatively new then, I would say. Right? Is it?
No, there's been an equity limit for a while.
Oh.
But it's indexed to inflation, so it keeps increasing, and it's more than what affects most Vermonters. But certainly, if you had a $2 million house, it would be an issue.
Okay.
What's the limit?
I don't have that exact figure at my fingertips. It's I think it's over $650,000 at this point.
Thank you.
So obviously,
So-
it
so,
depends on where you are and what kind of house you have.
So Matt, if you could just identify yourself for the record since you jumped in, which is fine, but just so people know who just commented on that.
Yep. So I'm Matt Getty. I'm a lawyer in Rutland, and I chaired the VBA study committee on this bill.
Okay, great. And we'll be getting to you after Mark. So thank you. Okay, Mark, go ahead.
So I'm at 4106B, and basically what that says is when you disclaim, you can't say, I'm disclaiming it, and oh, by the way, give it to this child or that. No. You can't do that. You could just only put your hand up as a stop sign, and then we have to look at the instrument and says, okay, well, what happens if you predecease? Where would it go? Okay, so you can't control where it goes. Otherwise, it's a gift. And also what the this act does that the previous act does is it says it sort of broadens who to disclaim. It's not just individuals. Charities can. Charities can disclaim as well. So, and in fact, I'll just digress here. I've got a case right now where this woman died. She didn't have a spouse. She didn't have children. And her will named her attorney to be the executor. He said, I'm not doing it. I decline. The alternate was her accountant. She said, no, I'm declining too. So we were without this executor. Deep in her will was M&T Bank was appointed as a trustee of a grandchild's trust. So somebody goes knocking on the door of M&T and said, we're without a fiduciary in this estate. Would you be willing to do this? And M&T said, yeah, we'll do it for you. So the next step is section 107 of the probate code says it can get allowed, the will can get allowed if you got the consent of the surviving spouse and the heirs at law. So surviving spouse, none. Heirs at law, well, she had no children. So we had to do an heir search and we found out she had 2 cousins. And one was actually named in the will, but the other one wasn't. So we send out the notices and the one who's named in the will signs it right away. Yeah, I agree to allow the will. The other one, radio silence. So now I have to go and say, okay, we don't have the consent of the heirs. We got to go to a hearing. So we go to a hearing, or I asked the court, we need to set it up for a hearing. He said, okay, notify the beneficiaries. There were 31 of them. And so one of the gifts was to a husband and wife. And so we just sent out one notice to the husband and wife because they were getting $5,000 together. And our probate court judge said, no, you have to notify both of them individually. I thought that's bad. And then there was a minor, so we notified the parent. And he said, no, you got to get a guardianship for the child. I said, what? And I said, and so finally when he issued that ruling, I said, I wrote a letter because I wanted to be kind to the judge. I said, would Your Honor be persuaded, but if you looked at section 107.3 or something that says that a parent at this stage of the game, the parent can side for the minor. And he said, well, I treat it as a motion. I'm denying your motion, but he granted the hearing anyway. So I was happy. But it took us over a year to get this will allowed because of all these complications. There's a charity that's getting something and they don't want it. Guess what? Under our act, they're too late to disclaim. Their interests got vested when she died. So it's too late for them under that act. Under this act, they'd be able to disclaim. And charities don't necessarily want what you give them. Particularly museums, they said, yeah, your art, we don't want to tell you that it's really ugly, but it just doesn't fit with our collection. So we're just saying, okay. And so, and then the act is good because it says, okay, if you disclaim, it's going to go according to the document. But if it goes to your estate, this is a great rule in this act. If it goes to your estate, you don't have to send it to probate. We'll look through your will, and we'll give it to the people who are in your will. We'll avoid the whole probate administration. I think that's genius. Okay. And then it also says that and then let's say there's nobody and it goes by intestacy, but you don't really have anybody, then it will escheat to the state. So we all know about escheat right here. Goes to the treasury. 4107, second ancillary rule, and then we're really go fast. This is a rule. This is about when joint people own. Okay, so let's say you have father and son own a bank account together. They add the name. What it allows is the law presumes that they own 50-50, but the presumption is rebuttable. So what this statute says is, hey, survivor, you can disclaim the greater of your per capita share by the head per capita, or what the consideration furnished was. So if your dad put 100% in that, you could disclaim 100% if you want. Okay, you put in 60%, you can do 60%. If you put in 40%, you could disclaim 50%. Okay, so that has clarity that we did not have before. So that's really great. And that usually takes effect upon the death of the co-owner. That's when you can have the right to disclaim. Okay, now I'm going to take 4108, 4109, 410, and 411 as a quartet because they're all dealing with the same issue. And this is when third parties can, other than the person who is getting the donee or the legatee is getting it, these are third parties. So 4108, basically the rule is trustees have the ability to disclaim. So assets are coming into the trust. The trustee says, no, I don't want to take this little triangular piece of land that's by a clover leaf on an interstate that I'm never going to be able to sell and I got to pay taxes on. No, I don't want it. Okay. So they have the power to disclaim access. In 4109, let's say that you've had a trust and the trust has given the child a general power of appointment, so it's going to be includable in their estate. They say, my estate's too big. I don't need to disclaim that. I don't want to have this power because it's going to be includable in my estate for estate tax purposes. This act, which the other one didn't, allows the person who is vested with that power or was granted this power of appointment could say, I don't want the power. And then they can also say, I want some of the power, but not all of the power. I want to be able to maybe decide among the descendants, but not the creditors, not my creditors, not my estate, not the creditors of my estate. So that's a very tax oriented thing. So that's 4109.
And
Karen has a question.
this is me just trying to understand the full picture. So if somebody disclaims property or funds and there's not a next person, what happens?
Well, what we do is we have a lot of hurdles to go through. So we look at the trust and say, what does the trust say?
Yeah.
If all these people are dead, where does it go? And most directors of trust, we try to have a disaster clause. It says, and it's a lot. Our favorite one is it goes to my heirs at law on the state of my intestacy under the state of Vermont. It's a big one. It could say charity, but if there's absolutely nobody, goes to Secretary of Treasury, insists and disclaim property, and I looked it up. I think they before it is cheats to the state. I think it's a 3-year time limit. I think so. Okay. So now let's say they've executed the power of appointment and they said, okay, these are the kids that are going to get it. 4110 says you're the appointee. This says appointee says, oh, I don't want it. Dad may have exercised the power to give it to me, but I don't want it, So, and that also applies for takers in default, meaning this is that a lot of times we grant these powers to these trust beneficiaries, but a lot of times they don't exercise them. And we have to have a provision in there that says, well, what happens if they don't exercise? And typically what it says is it goes to their heirs, it goes to their issue per stirpies. So it just filters down the bloodline. And so if they're a taker in default, they have the ability also to say, hey, I don't want it. And it probably will go past that. It treats you as if you predeceased. And then if you deceased, it usually goes to your issue per stirpies. And then 4111, this is when trustees are, particularly trustees or executors, if they've been given a power, then they can say, I don't want this power. So when would that occur? Here's the number one answer on the big board. Is a lot of times when we're drafting these trusts, husband drafts it for wife and he sets up a trust for the wife's life. He usually names his wife as the trustee. He can do that, And the concern is that what if you gave the wife a power that was so great it would be includable in her estate instead of bypassing it? She might want to say, oh, I want this to bypass my estate, so I'm going to disclaim that power that my husband gave me. And they can do that. And they'd have to do it within 9 months if they don't want to treat it for gift or for tax purposes, but they can do it under this act, which is great. So trustees can disclaim powers. Okay. On to 412. This is a long and important statute, but I think we can run through it pretty quickly because it's conceptually it's pretty easy. In 412A, we have a few definitions. I just point out to you that these definitions are really internal to this section. So in 4102, we have definitions that are apply to the whole act. These definitions in A just apply to this act. And I don't really need to go into it. I think it's a little complicated. And it really applies to states that don't apply to us. So let's move on to B. Delivery can be by personal delivery, first-class mail, or any other method likely to result in receipt. So what I'm thinking of is, as you may know, in Microsoft Outlook, you can put when you send an email, you can put a feature on it saying, I want to know when this person opened up this email, you know? And so that you have a receipt function on your email so that you can, that works beautifully, you know, so you've got that. Okay, now we're going to go from the rest on. It's like we're going to talk about different situations. So if you have a will or intestate succession and you want to disclaim, you got to give it to the personal representative. Now, that is kind of a modern term that we have not adopted. So let me digress a second, 15 seconds. Wills. We have, if someone is named in a will, they are an executor or an executrix, okay? If you die without a will, you have an administrator or an administratrix. If you have a will, but let's say your executor is dead and no one's named, then you have what we call an administrator. We call it DBN. Or no, a CTA, cum testamento annexo. So we have.
Whoever reports his bill has to say that. You're paying very good attention, Skip.
You got all these questions?
Yeah. So cum
No more questions.
testamento annexo means cum with testamento, a testament, a last will and testament, annexed. So it's telling me if there's a CTA after that administrator's name, we've got a will. And this person was not named in the will, they were named by the court. And then there's DBN, which is de bonus non, meaning the goods. I'm not the first administrator and I'm finishing up what an administrator did before me, de bonus non. The goods are not administered. And you could be a CTA DBN, you know. So we have a broad class, which jurisdictions like Florida have said, let's just call them personal representatives instead of these Latin words. I kind of like the Latin words, but you know. So and then if there is none, you can always file it with the court. So notice this section is called delivery and file. So there's usually, we're going to talk about delivery, but our resort is usually file. Okay, next one. Testamentary trusts delivered to the trustee. So testamentary trusts. What are testamentary trusts? So wills, trusts usually come in two flavors. One is wills, trusts that are built into the last will and testament. They're called testamentary trusts. Those are outside or a separate document. They're called inter vivos, Latin for during life or sometimes living trusts. So this applies to, so if it's a testamentary trust, then you deliver it to the personal representative, and if there is none, you deliver it to the court. If it's an inter vivos trust, the question is the settlor alive, the person who created it? If they are alive, deliver it to them. If they are dead, deliver it to the trustee. Next one, beneficiary designation forms. Okay, so we're talking about, you know, life insurance policies. You know, you name who gets the life insurance proceeds when you die, or retirement account. Who gets the rest of your retirement account if you die before you pulled all the money out? With them, you deliberate it. If it's not irrevocable, you can send your disclaimer to the designator. Well, that's usually the plan participant who owns it. But if it is, let's say that person's dead, now you find you've got it, then you deliver it to basically the custodian, be it Charles Schwab or Fidelity or wherever, you know, wherever it is. So that's it. The next section, H, If it's real estate you're disclaiming, you got to record it. You got to put the world on notice that so that it's going to help with anybody who's searching title. The next one, joint tenants with right to survivorship or tenants by the entirety, you have to deliver this written disclaimer to the person who takes. If you disclaimed, you have to figure out where it goes, and you can deliver it to he who takes. Next one, if you're an appointee under a power of appointment or a taker in default, you have to deliver it to the holder of the power. But if there's none, then to the fiduciary trustee. But if there's none, file it with the court. Next one, this one I didn't really understand. There's appointees under a power of appointment, and I think it's talking about maybe fiducies, but there are other types of powers that, again, all appointees in K as well. They go to, if they're disclaiming, it's to the holder of the power, then to the fiduciary, then to the court. And then L, trustee disclaimers of a fiduciary power they deliver to, if it's like a testamentary trust, they would send it to the personal representative. If there's none, it goes to the court. If it's outside the court, they can send it to the settlor. But last of all events, it's to the court. And then finally, if you're an agent under a power of appointment and you want to disclaim maybe a power that was given to you under that, you discovered now that mom's now gone in the nursing home and you're reading for the first time that you've been appointed the financial agent over things, you can say, hey, I want to disclaim, and you have to give it to the principal, i.e. mom, or the principal's representative. So that might be you, if that's the case. Okay, moving right along. For 113, when disclaimers are barred. A disclaimer is barred when you've already said that you disclaim the right to disclaim. I release it, I'm not going to disclaim, I prevent myself from disclaiming. It happens on occasion. In section B, it's barred if, as I said, you can't take an interest in it. You can't say, hey, I want some of the income, and now I want to disclaim. Okay, you can't do it. You're barred by that time. You can't disclaim it if you've already conveyed it, because you've or mortgaged it, encumbered it, or pledged it. Okay, if you exercise some economic impact on this asset, particularly property, then it's too late to disclaim it at that point. And then if there's a judicial sale of the interest sought to be disclaimed occurs. So if there's a judicial sale, if you get to that point, you're too late to disclaim it. Okay. What's interesting is fiduciaries can disclaim a power that they've been granted, even if they've exercised that power. So it's a little bit different from property. I said, with property, you can't take an interest in it and then say, I want to disclaim. But with fiduciaries like trustees and executors, you might have used that power before, but it's not too late to disclaim it. Say, henceforth, I shall no longer have this power. So that's what this act is great. It's very flexible in that regard. Disclaimant can still disclaim non-fiduciary powers, but only if they have not used it in their favor. So again, I said, if you take the interest, you're using it in your favor. But there are ways that you might be able to use a piece of property where it wasn't in your favor, it was sort of ministerial or something like that. That doesn't present. If you've got to take an interest in it, and if you haven't taken an interest, it's still not too late, even though you may have done some other things. And the next one is your disclaimer is going to be barred if there's another statute out there in the Vermont Code that prevents you from disclaiming. So we might see something. Matt, you might be able to answer this because this comes up quite a bit, and I had to research this. But what happens if you have somebody on Medicaid and now their cousin out in North Dakota has died and left you their estate? Can you say, oh, no, I don't want to hit this inheritance. It's going to knock me off Medicaid. Can you disclaim it? The courts that I've researched have said, no, you can't disclaim. So there are other statutes out there that I don't know if there's a statute that we have passed in the Medicaid because I don't practice in that area very much, that says, no, you can't disclaim property. If you're a Medicaid recipient, you can't disclaim property coming in. So if it comes in, we want you to use that property up before we shell out more money to support you. So, and this is a little bit of a conundrum. This is F, and it says that even if your disclaimer is barred, okay, it still effectuates a transfer to the person who would take. So it's a little bit of an oxymoron, I think, because because one would say, hey, if it's barred, then it's void as if it never were. But the law makes distinctions between what's void as if it never were, and what's voidable. And this is more of a voidable type of situation where you've disclaimed, now this person is going to would take the property if it wasn't barred by law. They still get the property under this law. So I'm not really too sure what, we kind of have that in advanced directives. Our advanced directives said, even if you have a advanced directive and now you're on meds and now you're crazy and you're totally incompetent, you can still revoke your advanced directive. That's what our statute says. And when I asked, when it was rolled out, I said, that seems like an oxymoron to me. How can you be incompetent and have it say? And they said, it was in the previous statute. We just kept it. So that's how you make laws. So,
Chairman, I was gonna.
Yes, please, go ahead.
Not because I want to be the reporter. I want, just as you're talking about this and like, oh, we might just have to include this. Can you remind us about the uniform laws? Like, we have to keep it pretty much the same. What is can you just talk about that piece of it? Like take a step back of.
Oh, absolutely.
And I know we've gone over this before in previous years, but I forget what it is. It's like, I know there's a line, like we can't change certain things or maybe anything at all. I don't remember.
Just the opposite.
Oh, okay.
You
We
can
change
pretty
it
much
all.
change it.
Oh,
Yeah.
perfect. So we could get rid of this.
Yeah, you could get rid of it. Yeah, we've and indeed that has happened with almost all the uniform laws that we've had. And actually, Eric, I'm glad you're here because when we did the Uniform Trust Code, when the uniform laws are promulgated, they have official commentary. And we did the Uniform Trust Code. We actually printed that right in the book. And then what we did in our committee was we put, to the extent that we changed the law from the uniform version to the Vermont version, we put a Vermont comment and we said, hey, we changed it. We took out this word and we put this word in. We did not go so far as to explain why we did it or what our thinking was. We just wanted, our purpose was just to point out we're differing from the uniform law because we think it works better here and we can change it. If you make too many changes, it loses its uniformness, so we don't want to do that. But
would anybody know?
Right, but we do let some people know maybe we can put in a Vermont uniform, the official comment and then the Vermont comment. We'd like to do that if we could write in the book so that people are alerted to sometimes we're just tweaking the word, like.
So with this one, is this in the current version kind of how the uniform law is?
Yeah.
In its, I'm not thinking of the right word.
Yeah,
Original form.
Yeah,
There's no changes yet.
We did incorporate changes from the uniform law. This is not the uniform law. This is the committee that Matt was the head of, and we went through each section and we said, does this make sense? And should we make a change here?
Okay.
And Matt might be able to articulate some of the changes, but anything? Okay. And now I think we can speed through 114 to the end is pretty much boilerplate. So let me race through those. 4114 tax qualified disclaimers. Basically, this says, hey, if you meet those qualifications that are in 2518 within 9 months of the interest being created, it's in writing, it's delivered, and you didn't take an interest, then that's going to qualify under our act. So because that's a higher level of scrutiny that we're going to require under this act. So it's just saying, hey, if you meet that, that's going to make it under our act. You still might have issues with the Internal Revenue Service, but that's not our problem. Okay. 115. It has an oxymoron which says if a disclaimer is required or permitted to be recorded, then the disclaimer may be recorded. Okay, and well, that, who cares about that? It's the next section. It says the failure to record does not affect the validity as between the disclaimant and the taker. Okay, so it's sort of piggybacking off that last rule that I said that was in 113. That if your disclaimer is barred, it still is not going to affect the next taker. Okay. In 116, application to existing relationships. When you read it, you will probably not understand it because I didn't understand it. And basically you say, but the official commentary is great because it says, hey, if before the effective date of this statute, you were under the 9-month rule, you're not going to be able to revive that 9 months by this statute becoming effective. We're not reviving or letting you extend it. You're not grandfathered in under our passage. Okay. 417 electronic signatures. That also, you might be very familiar with them, but this is a very standard uniform law that's in all the uniform laws. And I really had to dig deep. I asked several people in my office, what does this mean? And I finally dug down and I found out what it's saying is under the Federal Act, the states have a right to write over it. And Vermont has exercised that right in Title IX, Section 270 et sec. And it says that electronic signatures are legal, valid, and binding. So I hark back to when I said you could probably disclaim by email because that electronic signature is going to be binding. Okay. Next section is uniform of application and construction, which is please try to construe this in conformity with other states. And that's one of the great things about the uniform laws is that we don't, we're a small population, so a lot of cases don't percolate up like they do in big states. And so this allows you to go and say, well, down in Florida, they passed this act, and here's what they did when they dealt with this property. So you can kind of look at the uniformness of it. 4119 severability clause saying if any for any reason, this is just boilerplate, if anything is can't be law under Vermont law, then the whole act isn't bad. It's not all tainted. It's just that section. Okay. And then finally, repeal, that this would repeal the previous act. Which we need to get rid of. And then 4121, I noticed that this is important because it's come up before in other things. And says it's going to be effective upon passage. So we had that come up, I think, in one of our acts that we previously did, because usually they're July 1. They usually but when in Senate was introduced, I don't think that we were not pushing it. We're neutral on that issue, whether it becomes effective July 1 or effective upon passage. So that is the walkthrough of the act. As I say, it's a big, big improvement over what we got on the books. And here's the big reason why, is in 1976, when they passed the Tax Reform Act, the amount that was excluded from estate taxation at the federal level was $120,000. The act was affecting about 7% of the population, believe it or not. So only at 120. By the time we got to the year 2000, it had moved up to 675,000. That meant that husband and wife could transfer twice that amount, over 1.2 million, to the next generation. And I remember when George Bush was running for office in 2000, he was against the death tax, and it was getting a lot of traction. And I thought, why is this act? It's only affecting 3% of the population now. It's at 1.2 million. Only 3% of people are affected by this act. Why is it getting so much political traction? Time magazine did a poll, and they found that 19% of Americans thought they were in the top 3% of wealthiest Americans. I said, wow, America's a great place. But now, so then it was an index for inflation, and it crept up, and in 06, 07, 08, it was at 2,000, then it jumps to 3.5. By 2010, it is 5 million. It dies. It gets resurrected by Obama on December 17th of 2010. And now we go through stagnation, and it's just going, because it's indexed for inflation. And there was no inflation between 2010 and 2019. It had inched up by inflation from 5 million to 5.5 million. Along comes Trump and the Tax Jobs and Tax Cuts Act. They double it. It goes from 5.5 million up to 11 million. And we called that the bonus exclusion, because in that act, under the Congressional Budget Act of 1968, I think it is, they said, hey, when you do these sort of things, it's screwing with our budget. So we got to take a look at this. So it was scheduled to sunset at the end of 2025. And by that time, from 11 million, it had gotten up just a hair under 14 million. It was at 3.993. Okay. And then, so it was scheduled to end at the end of last year, but along comes the one big beautiful bill. And in it, they said, we're keeping it at that level. And in fact, we're going to inch it up. We're just round up to $15 million. So at the federal level, we now have an exclusion for everybody, so spouses can transfer $30 million of assets to the next generation without estate taxation. Okay. So hark back to the beginning when I talked about whether it's going to be a gift. And let's say you have an estate of 7 million and you want to disclaim, and it's going to be a gift, or you're beyond the 9 months, and you say, I don't care if it's a gift, because it's going to eat up my $15 million exclusion. And I'm never going to get to $15 million. I can see that, I'm 90 years old. I'm sitting on 7 million. There's no way it's going to be 15 million by the time I die, because I can see the goalposts, where I am. So people don't care anymore about whether they're making a gift or not, because all they have to do is file a gift tax return, but there's no tax. And because of that, that's why this 9-month shackles that we have on the new act has got to go. We just got to free that up. It's just not relevant anymore.
Ian, did you have a question?
Yeah, just 2 questions. One specific one for page 8, for 108, the disclaimer for trustees. And is it just sort of, can we just assume that disclaiming an interest in the property or a trust that the trustees held to the terms of the trust in doing that disclaimer?
Say that again.
So we had there was some language in about how a parent needs to have an interest when they disclaim for a minor child. So I'm just curious, we don't have it. There's no check language in the trustee disclaiming for a trust. Is that just because we sort of assume that they're going to operate within the terms of the trust?
Yes.
Yeah. Okay. And then my other question, I guess, and it kind of goes to your final point. If you were to sort of put on a separate hat of devil's advocate for someone who would be opposed to getting rid of the 9-month cap, what would be that argument?
The only time I've seen the argument is from the IRS.
Yeah.
The federal a federal issue, because and I think that I sort of did a little research about particularly this distinction between general and special. And I was trying to figure out, this made no sense to me. So I researched it, and there were a series of cases that came out right before 76. And it involved various family members of the Cargill family. Might know that Cargill is the largest corporation in the United States owned by one family or, family unit. Okay, it's not publicly traded. And these cargo heirs were coming up and they said, one had general powers, one had special powers. And I think here's what the concept was from the IRS point of view was, hey, if it's a general power of appointment and it's stuck in mama's state, well, that's like a starting anew again, so the clock should start ticking again. But if it's a special and it's bypassing mom's estate, then no, we aren't going to start the clock over again. And they were looking just from their viewpoint about what they could tax and the revenues coming into the United States Treasury. But it made no sense from the position of the child who wants to disclaim because they don't know whether they're going to actually get it, whether that power gets exercised whether it's special or limited. They don't know if they're going to get it. So it seems to me that the clock shouldn't have run on them until they know they're actually going to get it. And that's where this act will change that.
So any other questions for Mark before we then go to Matt Getty? Ken and then Coach, and then we'll go to Matt Getty.
So you said we're only one of 2 states in the nation that hasn't changed this?
Yeah.
What's the other state?
We are in good company with, once again, Alabama and South Dakota.
So 3 states.
Yeah, we're the third. And so on a map, I think that it has been circulated, this little map. And the red one, the 2 red ones are there. And
I like those states, so I'm good with that.
But there's been a number of times, like we were the last. I worked on the Uniform Transfers to Minors Act. I think we were in company with Mississippi at the time. Most states had moved, and I do think that I had heard many years ago when I started working on this is that our legislature was sort of hostile to uniform acts. But that I think that uniform acts are good. They've been well vetted. They get the top people in the country to sit on these committees and think of everything under the sun they could come up.
Is there any idea why they've held back to the other states?
Oh, I think it's more of omission and, just inertia. It's like we have been on a number of these uniform acts. Rather, I think that if they took a look at it, they would. I don't think they're doing it affirmatively, like holding on to it.
Thank you.
Coach, unmute yourself. There you are.
Good morning.
Morning.
Thank you so much for that walkthrough. Very well done. It's an area of interest personally. As you start creeping up on that goalpost, as you mentioned, you start researching, this. But to get back to your point about the uniform acts, we have been getting more involved over the last, I'd say 5 years. 2.5 bienniums in uniform acts because they do more for us than they do not. And clearly, as we, as a state, come up on the goalpost, it becomes mission critical, that we move forward in that direction. So I just wanted to thank you for your, your detailed work and your presentation. Thank you.
Thank you.
Thank you. So yeah, as far as uniform acts and uniform laws as well, can't deal with uniform law without saying thank you to Rich Cassidy, who
Yes.
was really instrumental in getting us aiming towards doing uniform law commission work. Anyway.
Kudos to Rich.
Yeah. So Matt Getty, we'll turn to you, and then after that we'll take a break.
Okay, thank you. Just fair warning, I do have a client arriving imminently and will need to leave, but I did want to emphasize a couple of points and provide you a couple of anecdotes. One is, in terms of what you were just discussing, I just want to underscore that this bill is revenue neutral for the state of Vermont. So we're not changing the tax law at all. The tax law on this subject is governed by the federal statute, Internal Revenue Code. The 9-month window that applies for that purpose still applies for that purpose. But, as Mark pointed out, there could be situations where an individual would want to disclaim where the 9-month window wouldn't be relevant to their situation. And so having it in our statute is unhelpful. And in fact, the Uniform Law Commission emphasizes a point about the language that is in our existing statute in section 1952 that is actually misleading with respect to future interests in a way that could lead somebody who's just reading that statute to think that they can disclaim, but the language is inconsistent with the federal tax law. And so their point is that's a potential trap for the unwary. And if we just take this provision out entirely, we don't talk about timelines, people will know that if they're trying to disclaim for a tax reason, that they're going to look at the tax code for that, not at state law. So that was one thing. I think some months ago, when this was initially introduced, I sent to the chairman a red line of our version and how it varies from the Uniform Act. And I can send that again if that's helpful. We did make some changes, and there are Vermont comments with those changes. A lot of that just has to do with specific Vermont quirks. For example, Mark mentioned enhanced life estate deeds. So we modified as a portion of section 12 of the Uniform Act to make that specific to our situation and differentiate it from a provision that's in the Uniform Act that applies to states that have adopted the Uniform Probate Code and things like that that are not relevant to us. So there are a number of things like that. But for the most part, we try to keep these things as close to the Uniform Act as possible in order to promote the goal of these Uniform Acts, which is uniformity across states, so that, if for some reason, a practitioner in one state is looking at what the rules are in another state, they're going to look familiar.
So if you could send that to Nate, so we can put it on our website, that would be helpful. Thank you.
Yep, I will do that. Couple of anecdotes in my own practice that came up recently. I think Mark and I have talked about this several times over the years. For whatever reason, it would come up and we would say to each other, why do we have this statute with this 9-month limit? What finally spurred us to take action on this, I guess, was an aggravation I had in my own practice. I had a situation where an individual actually needed to file a tax qualified disclaimer, and I was looking at our statute and was feeling a little uncertain about the requirements for effectively making and delivering that disclaimer. And so this was a situation where there was no probate, all the assets were in trust, but I ended up, to make a long story short, I ended up filing an assetless probate with the county court just for the sole purpose of delivering this disclaimer so that there wouldn't be any question about whether state law requirements were filed in order to effectuate the disclaimer. So one of the things I really appreciate about this statute is section 12, the delivery provisions that tell you specifically how to deal with each kind of asset. Rather than just having some general language, it's much more particular. And so, sure, it makes the law longer, but as a practitioner, it's a lot easier to follow. It's kind of an instruction manual. Okay, here's my situation. What do I do? The statute tells me. So that would have been great to have in my situation. Another thing that came up for me recently was I had a couple come and talk to me who had inherited an interest in real estate. And this was an incredibly fraught situation with a complex family, unopened probates, just a total mess. But their part of the family tree was fairly simple. And unfortunately, they had received some bad advice about disclaimers in the past. They had not disclaimed. The time window was gone. They now own a share of this property, but their situation is one where, had their probate that they were involved in not being completed, um, disclaiming outside of the 9-month window would have accomplished their goal of title in this asset ending up in the hands of the people who actually wanted to own it. It would have been a pristine result. Now, they are looking to potentially make a gift of that to somebody, and they will have been in the chain of title, which could have environmental liability consequences in the future and things like that. So there are reasons why people may want to disclaim outside of the 9 months and not be bound by that. So I think those were the main highlights I wanted to emphasize, and I'd be happy to forward on that red line later this morning so that you all can review it in more detail.
Any questions for Matt? So I do have a question, but maybe it's for what Mark or Matt. So have the probate judges weighed in on this? How were they involved or not?
No, we haven't run it by the probate court judges, and it just sort of tangentially affects the administration of that.
So it's not that much.
Well, the one thing we do is the provisions are in there to at least put them on notification. We want to notify, particularly when it gets to at the end of administration, there's what we call the decree of distribution. And you have to say who's getting it. So they're going to have to know if someone who is named in the will has already disclaimed and so it's passing to someone else. They're going to, but you're going to do that. The practitioners will take care of that, filing it with the court.
So how much foreknowledge will the probate courts need to have, or training or anything like that on this? This has to go with whether the on passage effective date was appropriate or.
Yeah, usually what happens is that in a state, well, usually there's a final accounting, and that's usually when you prepare a proposed decree of distribution for the court, and then that's when you want to explain to the court, oh, by the way, if you read the will, you're thinking this person's going to get it, but they've disclaimed, and so it's now passing to their children. So you want to explain why there's a difference between what the will says and what they're actually doing. But it really doesn't have to be done, I think, until the court is ready to sign off on a decree of distribution.
So probably don't need to have a later effective date for that. But I have emailed Chief Superior Judge just to make sure that we've crossed that T, dotted that I.
Yeah, I think if another thought came up is that usually when a lot of times you have to give notice to everybody who's named in the will. But I think that, let's say if you say, I give so-and-so $100 and you pay the $100 and you have got them to receipt, and you file that receipt, you can drop that person off the service list. They're out of this, they don't have to get notice on what happens now because they got paid what they were paid. So I think that there would be you'd have more of an incentive as a practitioner to get that disclaimer in if you want to drop them off the service list. Yeah.
All right, so we do have to hear from Chris Delia, who had to be called away to another committee. Yes, yeah.
I'm Bob Paolini from the Vermont Bar Association. Chris left me his proxy because he had to.
Oh, well, all right, so let's hear from you. We'll have you come to the witness chair then. Yeah. So sitting in for Chris Delia.
Yes, please don't let anybody outside this room know that
I'm afraid you are on YouTube.
Again, Bob Paolini from the Vermont Bar Association, the first VBA. Chris Delia, we brought Chris in on this conversation back in the fall, December, maybe, when we had a draft. He's run it past his trust committee, and the Vermont Bankers Association, the other VBA, is in full support of this bill as passed the Senate. And he's asked me to put that on the record on his behalf.
All right.
One other point that I know Eric is going to make, Mark finished his testimony by talking about a provision he was reading from the bill as introduced. The Senate amended that bill on Eric's advice. There was the severability
Correct.
clause, which apparently doesn't, it's in every uniform bill draft, but it's not needed here because we have something in Title I
Right.
Right.
that provides it. So that's the difference.
Okay. All right. Well, thank you very much. So we don't have anything until 11 unless we want to talk Eric into doing a walkthrough of the bill at 11:45 instead. Will that work for you, Eric?
Yeah, whatever you prefer.
Don't have it printed yet. So
Well, that gives us 25-minute recess. So we'll go off live and we'll be back at 11:45 to take up S203.